Brief.
Madam Speaker, I want to seek your indulgence on a matter that I think is... Hello, Madam Speaker, Mr. Speaker. Mr. Speaker, you know, when I saw a black man, I just knew things have changed. So, Mr. Speaker, I want to bring to the attention of the House a matter that is very important. Mr. Speaker, as you are aware, the issue of our main business here is legislation. And one of the biggest predicaments that we have faced on issues of legislation, Mr. Speaker, is the issue of public participation. Public participation. So, Mr. Speaker, I want the House to take note of the ruling of the Supreme Court that happened the other day, Mr. Speaker, on the finance bill that was suspended by the court, Mr. Speaker. And the bench at the Supreme Court did a very thorough work, Mr. Speaker. And I want to congratulate them because they have laid basis and foundation now for a proper public participation, Mr. Speaker. Mr. Speaker, I want to urge members to read that judgment, Mr. Speaker, because that judgment has really, really helped this country. It has cleared the path for this country now and for Parliament to do proper legislation, Mr. Speaker. Mr. Speaker, for the last 10 years or so, since the new constitution was enacted, Mr. Speaker, Parliament could not do this business, Mr. Speaker. Any legislation we do here, any act that is assented to by the President, Mr. Speaker, somebody goes to High Court, and the High Court declares that act unconstitutional, Mr. Speaker, when in the actual sense, an act could have 73 or even 80 clauses, Mr. Speaker. And instead of a judge declaring the 10 or 15 clauses that someone has a problem with, many times judges have declared acts of Parliament unconstitutional, Mr. Speaker. If you read the judgment of the Supreme Court now, Mr. Speaker, and I read that judgment last night, it gave me a lot of hope. And I said I must bring to the attention of members that now the country is going to the right direction in terms of legislation. The Supreme Court said, one of the best things the Supreme Court said is that Parliament doesn't have to convince the public on what they are doing or the legislation. They just need to inform them. Information, Mr. Speaker. You don't have to convince, because we are here to legislate on behalf of Kenyans. We are exercising sovereign power that is delegated to us, Mr. Speaker. The Supreme Court, in their own wisdom, said that you just need to inform the public. You don't need they don't have to agree with you. Because legislation is not being done in the public, it's being done in the floor of the House. One of the things that has shocked me about public participation, one time, one of the judges declared one of the acts unconstitutional. And he said that the advert that was released to the public was done in English and not Swahili. And himself is doing his judgment in English. He did not do it in Swahili, Mr. Speaker. So, Mr. Speaker, without belaboring the matter, time is ripe now for the public participation bill to come to this floor of the House. The Supreme Court has spoken on it. The Supreme Court has cleared the path. Now we need to get a proper public participation bill on the floor of the House so that we can dispense off with that matter once and for all. Kenyans have suffered. Kenyans have suffered in the sense that any legislation that is made by their representatives is normally declared null and void and unconstitutional by the courts, Mr. Speaker. The courts are legislating through, I don't know how to describe it, through the back door, Mr. Speaker. So, Mr. Speaker, that matter must come to a rest. But I want the majority leader to weigh on this matter. And I also have the issue of femicide, Mr. Speaker. Femicide. Our women are being killed, Mr. Speaker, Kenyeji. Even today, there is one that has been killed and her body parts thrown at Isli, Mr. Speaker. At Isli. Another one, Atlangata. But her origin is from Isli. So, Mr. Speaker, that matter also we need to talk about it, but let the majority leader pronounce himself on the issue of the Supreme Court and public participation. Thank you.
Thank you, Honorable Speaker. Let me
first commend the Leader of Minority, the Honorable Junet Mohammed, for raising this issue on the matter of the judgment, and also take this opportunity to commend the Supreme Court. Because, Honorable Speaker, the architecture of a constitution, and we must thank God that under the 2010 Constitution, the Supreme Court came into being. Because, Honorable Speaker, as an advisory court also, they have now set the pace, as the Honorable Junet Mohammed says, for us to be able to enact substantive legislation to guide our public participation exercises in the legislative processes of this House and even those of the other House and our county assemblies, Honorable Speaker. Honorable Speaker, I want to agree with the Leader of Minority that in line with Article 2 of our Constitution, that says that the people may exercise their sovereign power either directly or through their democratically elected representatives. And those democratically elected representatives are the men and women who sit in this House and in the Senate, Honorable Speaker. And more so in this House, because it is this House that represents the people. And that is why you will find also in this Constitution, many of the bills that become law can emanate from this House and become law without going to the other House, to the Senate, Honorable Speaker. Because we represent the people while our Senate colleagues represent our counties. And that is why those bills that touch on counties and county governments must, as a matter of the Constitution, go to the other House and may also emanate from that House, but must be completed in this House. And that is why I've always argued, Honorable Speaker, since 2013, when we began this new system with the bicameral parliament, that we don't need to belabor which House is superior to the other. If one House can enact legislation and it becomes law by itself, and the other House cannot enact legislation and it becomes law by itself, it has to go to the other House, then it goes without saying which House is the upper House, Honorable Speaker. But that is not the point, Honorable Speaker. The point is that public participation has been abused by a number of our judges, especially in the High Court. And I must commend the Supreme Court and those other judges who have exercised judicial restraint in making determination as to what constitutes good public participation. And I have listened, I've read previous judgments on qualitative and quantitative analysis of what is good public participation, Honorable Speaker. But the Supreme Court now has put it very well. And I want to agree with Honorable Junet that it was misconstrued that public participation is a referendum. And in fact, during the public participation exercise of the impeachment process of the former deputy president, there are those who argued that way. And there are those who believe that we are going to carry out a referendum exercise. Public participation is to go out and collate the views of the public. But it's still up to the members of parliament to consider the views of the members of the public. And they may not necessarily be the right views. And you know, Honorable Speaker, it is said that opinions are as many as, I don't want to say what they say out there, but you know what they say, that opinions are as varied as you know what. And everybody has theirs. Therefore, as many views as we will get from the public, Honorable Speaker, the onus is still on us as the lawmakers to consider all those views, balance those views against what the legislation that we are making seeks to achieve, Honorable Speaker. And I'll take you back, Honorable Speaker, to the Finance Bill 2024. And Honorable Speaker, because I have seen the CS of National Treasury bring in a number of proposals that were very good proposals that were carried in the Finance Bill 2024, Honorable Speaker. We went out to collect views of the public through the public participation exercise that the member for Molo, the Honorable Kimani Kuria, spent, I think, close to 14 days seated in County Hall, listening to Kenyans. And Kenyans came in their numbers to give their views. They said they do not want taxation on bread. They said they do not want to see taxation on motor vehicles. Kimani Kuria and the Finance Committee did a report
which was tabled and adopted by this House in second reading, agreeing with members of the public that there should be no taxation on bread, no taxation on motor vehicles. Kenyans out there from the manufacturing industry, Honorable Speaker, appeared before the Finance Committee and told them that we are killing our manufacturing industry in Kenya because we are encouraging more of imports than local manufacturing. And it was players in the manufacturing industry through KEPSA, through the Kenya Association of Manufacturers, that brought proposals that would protect our local manufacturing industry, made proposals to levy excise duty on completed or finished products being imported from China, the Far East, Europe, including diapers and sanitary towels. But what happened, Honorable Speaker? The public were incited to believe that this House was levying tax on all diapers, on all sanitary towels, and you will remember our young daughters telling us in their parlance out there how our bunge hata hawataki tunyeshe sasa. You know, Honorable Speaker, how embarrassing when we saw it was when we watched our daughters, our teenage daughters, telling us that hatutaki wanyeshe. Whereas it is them that we sought to protect. It is our young mothers, our young daughters, our sisters we sought to protect from cheap, completed products of sanitary towels, which nobody can authenticate how hygienic they are. The standards that they've been manufactured under in the West and in the Far East, Honorable Speaker. And some of these Far East countries, Honorable Speaker, you know, they have no standards. You get what you pay for. And it is that we sought to levy excise duty on, so that we protect that local manufacturer who is manufacturing sanitary towels in Mlolongo, another one in Ruiru, another one in Juja, another one in Nakuru, Honorable Speaker. It is the farmer in Western Kenya and Luo Nyanza and parts of Nyanza, Honorable Speaker, that we sought to protect, who has now been given cotton seed, BT cotton seed, to produce cotton for the value addition of these manufacturing industries, Honorable Speaker. It is the Kenyan youth who are on the streets we sought to protect, to create jobs for them in those factories here, Honorable Speaker. But what did we do? We were told, reject. We rejected, we lost jobs. We rejected, we exported jobs to the Far East. No wonder, Honorable Speaker, today, when CS Mutua announces 3,000 jobs, in Qatar, 30,000 Kenyans turn up at KICC. I want to plead with the Kenyan people, and more so our fourth state, Honorable Speaker. Let us be responsible in how we communicate to our people, because we end up misleading our people, and at times even us as political leaders, we are guilty, because we end up saying what we think is popular with the public, but not what is right. And I've said here, Honorable Speaker, before, what is right is not necessarily what is popular, Honorable Speaker. Therefore, in terms of public participation, I want to ask all our committees, when we embark on public participation, our work is to listen to the views of the public and balance it against the legislative proposals that we have and against the policies that we seek to anchor that legislation on, Honorable Speaker. Because it is only you who, upon being elected, like the member for Kajiado South, the people of Kajiado South believe that the member of Kajiado South is the best amongst their people, Honorable Speaker. And therefore, because he's among the best of Kajiado South constituents, they entrust him to come and make laws on their behalf. And therefore, they expect the member for Kajiado South or the member for Kikuyu to know better. And by knowing better, to be able to know this legislative proposal that is before the House is anchored on the policy of import substitution. And therefore, you must balance the question of import substitution, the policy of import substitution, against the legislative or the tax proposals being made vis-a-vis the interest of business people who are importing cheap products that endanger our women, our young girls, Honorable Speaker, and it is only these honorable men and women in this House who can do that. Therefore, in conclusion, Honorable Speaker, let me inform the minority leader that indeed the office of the Attorney General is in the wee hours of finalizing on the public participation bill, a substantive bill that now, even further informed by what the Supreme Court has said, will guide our public participation exercise moving forward, Honorable Speaker, so that we do not find many of the statutes that we enact into law in this House and in the other House, Honorable Speaker, being rendered unconstitutional on the basis of public participation. With those few remarks, Honorable Speaker, let me conclude by commending the honorable ladies and gentlemen in the Supreme Court who rendered that judgment that was very well informed, and we can now comfortably say that that Supreme Court has men and women, Honorable Speaker, who weighed in on the issues that will guide our country very well moving into the future. Thank you, Honorable Speaker.
Thank you very much, Honorable Speaker. Honorable Speaker, I also want to join my colleagues, the minority leader and the majority leader. Number one, in commending and appreciating the judgment made by the highest bench, the Supreme Court, as far as public participation is concerned, Honorable Speaker. Honorable Speaker, there was, like the minority leader has said, this can only be related to a study in jurisprudence, Honorable Speaker, that you and I know on a particular case. We call it the Spelunchian Explorers case, Honorable Speaker, and you and I know that very well, where because of lack of written law and quality jurisprudence that would have either convicted or acquitted the explorers, the Spelunchian Explorers, Honorable Speaker, there arose confusion in the bench where we found the Chief Justice hardly making decisions in that case. We found a positivist in the bench, I think Justice Keane. We also found a clear naturalist and one who even never wanted to touch. This question of public participation, Honorable Speaker, has brought a lot of confusion within our high courts and within our courts, Honorable Speaker, where one judge's view in the high court in Kajiado, another judge's view in Kisii, another judge's view in Kerugoya, another one in Mombasa, and another one in South Mogrango. Very soon we'll get a high court in South Mogrango. We are lucky to have a magistrate's court so far. Honorable Speaker, when you read such laws, you will then be left wondering, and this House will be left wondering, which particular judgment would you, want to refer to when creating your own jurisprudence in terms of making the public participation worthwhile, Honorable Speaker. And that is why it is very important for this Supreme Court to have come with a clear distinction on what this House on what this House ought to do in terms of public participation. Because, Honorable Speaker, I was mesmerized by definitions of what a quality. You know, I read one judgment that said what was a quality public participation. The parameters one created. You know, what we are suffering from, Honorable Speaker, is actually what I would call judicial activism, where some people, and I say this with tremendous respect to members of the judiciary, where some members of the judiciary, Honorable Speaker, decided to be activists and populist, start making populist decisions. In fact, you'll even be, you'll be forgiven if you actually predict the outcome and then it comes exactly as it is, because you would see conversations on social media on how a judge would interpret this public participation direction, and the following day when you read that judgment, it is as exactly as it was written by some people on social media. I mean, this is mere judicial activism, Honorable Speaker. And the direction the Supreme Court has actually given us as far as public participation is concerned, it is a right jurisprudence. But again, I challenge this House to expedite the process of creating this law on public participation and create parameters. In as much as now we are using the jurisprudence that has been created, Honorable Speaker, it is important for this House to expedite such laws, and I think the Chairman is here and is well noting, and then we expedite such process so that we do not have such similar confusions in future, Honorable Speaker, where the same procedure used on a particular bill is is rendered mute, while there's a similar procedure that has been used on a different bill has gone through a similar procedure, passed and enacted, and it's now law. That kind of confusion, Honorable Speaker, couldn't be explained. We had lost quality on making our jurisprudence in courts, and we really must commend the honorable judges for coming up with such very serious directions as far as this jurisprudence is concerned. Thank you very much, Honorable Speaker.
Justice and Legal Affairs Committee.
Thank you very much, Mr. Speaker.
I've not allowed you to speak. Yeah, it takes the speaker to recognize you. When the speaker doesn't and you insist, you become disorderly and it may cost your presence in this afternoon. Yes, so you are not yet recognized. Let Honorable Murugara proceed.
Thank you. Thank you very much, Mr. Speaker. Mr. Speaker, the issue of public participation is a very important issue in this country. And we allowed the Supreme Court for the interpretation and the guidance it has given to the House and to Kenyans as regards what exactly is public participation and to what extent should this House consider views collected from the public during public participation. Indeed, it is true, many people think that when we go for public participation, we should be collecting views and votes from the public, so that if the public votes against whatever it is we are proposing, then it fails. Nothing is far from the truth than that, because the fact remains public participation is purely to ensure that our public is well informed as regards the legislative proposals we have here or whatever action Parliament is taking, so that the public does not plead ignorance at any time. Two very important things to say. JLAC has two drafts of public participation acts, which we are looking at. In fact, we had scheduled December to be our deadline, so that we are able to produce something for the House to look at. But we are happy to hear the Leader of Majority saying they are also working on an act of Parliament, which will be coming to us in due course and which we will be debating when the right time comes. Because part of public participation is the question which recently, on Monday, the newly appointed Deputy President of the Republic of Kenya, Professor Kithure Kindiki, posed to the judiciary. What is the difference between the public interest and the national interest? And which of the two is higher than the other? Because as far as public interest is concerned, and that goes with the public participation, there may be an element of mobilization towards rejecting a popular idea of the government. Is that what you should be calling public participation and the public interest? Or we should be looking at the bigger good of the country, what is beneficial to the country, and we should be carrying that as actually what entails public interest. All this is going to come before the House. We have to prepare ourselves so that we can enact one of the best laws in the country, guided by the judiciary, so that we produce an act of Parliament on the public participation, which is acceptable across. Thank you very much.
Honorable Kimani Kuria, you want to speak to this? I hope you are not laying. Okay.
So, Honorable Chair, Honorable Speaker, I want to join my colleagues in celebrating the Solomonic wisdom of the ruling by the Supreme Court of the Republic of Kenya. Honorable Speaker, the reason why the finance bills for the last 2 years have become a subject of discussion in the whole country is because the Departmental Committee of Finance and National Planning made a deliberate decision that we would engage members of the public to seek their views and to have their voices heard on the matters that are going to affect their lives and matters that are going to affect our economy, Speaker. I, however, noticed, Honorable Speaker, that during the process, perhaps what we should have started with was civic education on what is a law-making process and how is a law-making process done. Because, Honorable Speaker, we saw even very educated people display their ignorance on the process of lawmaking. Honorable Speaker, I dare say that we had one of the most progressive reports that the Finance Committee of Finance and National Planning Committee tabled in this House, and this Honorable House approved at the third reading. The issues that members of the public were raising had sufficiently been addressed in our report. And how we are finding now, Honorable Speaker, now, is that those matters that should have been passed in, for example, reducing the weight of taxes on payslips by making these statutory deductions like SHA and housing levy become tax allowable for payee, were matters that we had considered. Honorable Speaker, we have thousands, if not millions, of Kenyans that were locked out of tax amnesty, a matter that we had considered and extended the tax amnesty to next year, where we are saying you pay your principal tax, or you have a commitment to your principal tax, and you have your interest and penalties all forgiven. But, Honorable Speaker, these matters were left, and we are hoping that as we consider several other legislative proposals that are coming to this House, that both the House and the members of the executive should consider civic education. And I'm happy because even our civil societies and our activists and even upcoming politicians have now taken upon themselves to understand how laws are made in this country. Honorable Speaker, even as we had the previous discussion about the impeachment of the Deputy President, there were questions about comparing how the process of assumption of office of a Deputy President was compared to that of the President of Botswana. Honorable Speaker, the difference is we have our 2010 Constitution, we have several laws in this country that spearhead such a program. And until a time when we change our Constitution or we change those laws of Parliament, those particular statutes and laws, then that will be the procedure. And therefore, I'm urging Kenyans that during the various respective legislative proposals that are coming to this House, the bills that are coming to this House, let us follow our Constitution, let us follow our laws to do it according to the laws of the Republic of Kenya. And let us take time to understand the lawmaking process, because unfortunately, we have no shortcut, because we must adhere to our 2010 Constitution as passed by the majority of people in this country. I beg to submit, Honorable Speaker.
As I will only give 2 more members the opportunity to comment,